some changes to the normal practice in order to support the new call list system and ensure that social distancing can be respected. Members should sanitise their microphones using the cleaning materials provided before they use them and respect the one-way system around the room, which is that way. Members can only speak if they're on the call list. This applies even if debates are undersubscribed. Members cannot join the debate if they're not on the call list. Members are not expected to remain for the wind-ups. I remind members that there is less of expectation that members stay for the next two speeches once they have spoken. This is to help manage attendance in the room. Members may wish to stay beyond their speech, but they should be aware that in doing so they may prevent members in seats in the public gallery from moving into the horseshoe, which obviously is not going to be a case today because we're not oversubscribed. Can I say order, Joanna Cherry to move the motion?
Thank you, Mr Twigg. It's a pleasure to serve under your chairmanship, and I rise to move the motion that this House has considered the Lord Chancellor's oath and the rule of law. I should start by declaring an interest here as a non-practising member of the Scottish Bar, the Faculty of Advocates, as an honorary bencher of the Middle Temple, and also as the lead petitioner in the case of Cherry against the Advocate General, in which connection I refer to my entry in the Register of Interests. Mr Twigg, the Lord Chancellor is required to make an oath that no other member of the Cabinet is required to make, and it reads as follows: I do swear that in the office of Lord High Chancellor of Great Britain, I will respect the rule of law. And when the Lord Chancellor took oath in July last year, he took office in July last year, he took that oath at the Royal Courts of Justice. Yet, Mr Twigg, the past year has not been a happy one for the United Kingdom Government in respect of the rule of law. In September last year, the Government suffered defeat in the Supreme Court of Scotland and the Supreme Court of the United Kingdom when the Prime Minister's prorogation of Parliament was ruled unlawful. And rather than a contrite response, what we saw was a combative one laced with denial. And the fallout of these cases, the Miller case and my own case, and the first Miller case, has been to lead to repeated attacks on the legal profession and the judiciary, and now also proposals to restrict the right of judicial review of government action. So that was the start of the Lord Chancellor's year of office. First year of office. It's been bookended this September by the UK Government's Scottish law officer's resignation, and it will be recalled that the Advocate General resigned last month with a letter informing the Prime Minister that he found it increasingly difficult to reconcile his obligations as a law officer with the Government's policy intentions, and he has yet to be replaced. Now, the Advocate General for Scotland tendered his resignation in the wake of the Secretary of State for Northern Ireland's statement that the UK Internal Market Bill would break international law in a very specific and limited way, an admission that, of course, was elicited from him by the Honourable and Learned Member for Bromley and Chislehurst. In addition to the Internal Market Bill, we currently have two further bills before Parliament which are unprecedented in legal terms. Both the Overseas Operations Bill and the Covert Human Intelligence Sources Bill both seek to create special classes of defendants in domestic law in respect of whom the criminal law will not apply as it does to you or me, Mr Chair. And we also have reviews in administrative law and human rights pending, which would appear to threaten the scope for British citizens to challenge unlawful actions of this government in court. And of course, Part 5 of the Internal Market Bill already seeks to do that in respect of certain aspects of the Northern Ireland Protocol. There are concerns, Mr Chair, that the Internal Market Bill will undermine the Good Friday Agreement, and it certainly runs a coach and horses through the devolution settlement and makes a nonsense of promises made to Scottish voters during the 2014 independence referendum. Now, last week, Mr Chair, I spoke at a webinar organised to discuss the implications of the Internal Market Bill for the rule of law, and it was organised by the International Bar Association's Human Rights Institute. The webinar was attended by over 1,000 lawyers from across these islands, and there were a further 1,000 in the waiting room that were unable to get in. And amongst the speakers who expressed concern about the implications of the Internal Market Bill for the rule of law were not just lefty lawyers like myself, but also the Baron Howard, Michael Howard QC, the former leader of the Conservative and Unionist Party, former leader of Her Majesty's opposition, who I don't think in any stretch of the imagination could be described as a lefty lawyer. So the concerns I'm articulating today are felt across the political spectrum. And it was very noteworthy that during that seminar, Lord Neuberger, the former President of the Supreme Court, expressed very grave concerns about the implications of the Internal Market Bill for the rule of law. And such concerns, when expressed in such trenchant terms as have been widely reported by a former President of the United Kingdom Supreme Court, are of some significance. And they reflect the huge and widespread concern across these islands, expressed by the law societies and the bars of Scotland and England and Wales, about the bill, but also about rhetoric employed by the Home Secretary and the Prime Minister in respect of the legal profession. Now, at the beginning of September, the Home Secretary claimed that, I quote, activist lawyers were frustrating the removal of migrants from this country. Now, days later, an immigration solicitor was the subject of a violent racist attack in a London law firm, and the Law Society of England and Wales wrote to the Home Secretary, warning her that inflammatory rhetoric has consequences. But nevertheless, Mr. Chair, the Home Secretary has doubled down on her rhetoric, and she's been joined in it by the Prime Minister. At the Conservative Party conference, the Home Secretary criticised people who make endless legal claims to remain in respect of asylum cases, and in the same speech she referenced those who lecture us on their grand theories about human rights, as well as do-gooders and lefty lawyers. And the Prime Minister, in his conference speech the next day, reiterated the sentiment, saying that the government were changing the law and stopping the whole criminal justice system from being hamstrung by what the Home Secretary would doubtless, and rightly, says the Prime Minister, call lefty human rights lawyers and other do-gooders. Now, Mr. Chair, the leader of the Scottish Bar, the Dean of the Faculty of Advocates, was so concerned about these comments that he's written really what I would call an unprecedented letter to the Prime Minister, in which he has expressed grave concerns on behalf of the whole Scottish Bar. And I'd like to read it out because it's a short but powerful letter. And it starts as follows. Dear Prime Minister, as I hope you know, the Faculty of Advocates represents the Scottish Bar. All advocates qualified to practice before the Scottish courts are members of faculty, and all are bound by the cab rank rule. And he goes on to explain that the cab rank rule means that advocates must be available for instruction by all and can't pick and choose their clients. And he goes on to say, against that backdrop, I require to intimate as Dean of Faculty and on behalf of all members of faculty that I deprecate the recent pronouncements from the Home Office, then from the Home Secretary, and latterly from the Prime Minister himself, to the effect that there is a problem with lefty lawyers or activist lawyers who are hamstringing the justice system. Whether the topic is immigration or crime or the Constitution, lawyers that act against the state are not being lefty nor activist. They are doing their professional duty. It is simply unconscionable for Her Majesty's government to decry in this way the actions of professionals who, as the comments of Lord President Ingalls in the famous case of Batchelor versus Patterson and Mackersey, these comments make clear that lawyers are not at liberty to pick and choose between their clients. And the Dean of Faculty goes on to say, in this country, by which I presume he means Scotland, but I think he would also apply it to the whole of the United Kingdom, he says, in this country, and the same cannot be said of all countries, instances of violence against lawyers are fortunately rare. However, in a climate of increasing populism, this sort of rhetoric is not only facile and offensive, it is potentially harmful. With great power comes great responsibility. And I have to say, says the Dean of Faculty, with great respect, that I simply cannot fathom why it is thought in any way appropriate to attempt to vilify in public those that are simply doing their job in accordance with the rule of law. I would accordingly, and again with great respect, ask each of you to eschew such unhelpful language and to recognise that challenges to the executive are a necessary part of our democracy. Anything less would be a confession that we no longer live in a democracy. And that letter is signed by Roddy Dunlop, QC, Dean of the Faculty of Advocates, who I think, as an old friend of mine, I can assure you, he's not, unlike me, a lefty lawyer. He's simply somebody who cares about the rule of law. Now, I realise as I look around this debate that there are many lawyers in the debate, Chair, and I don't think I need to take up too much time by defining what the rule of law is. That great English jurist, Lord Bingham, has set it out very finely in his 8 principles of the rule of law. But it's worth just reminding ourselves, in relation to the Internal Market Bill, that the 8th principle, the 8th of Lord Bingham's principles, is that the state must comply with its obligations in international law as in national law. Now, turning to the responsibilities of the Lord Chancellor for the rule of law, I think these were very well set out in a December 2014 report from the House of Lords Constitution Committee, where they said, and again I quote, "The rule of law is a fundamental tenet of the United Kingdom Constitution. In the context of the government, it means more than a simple compliance with the letter of the law. It means governing in accordance with constitutional principles. The Lord Chancellor has traditionally had a key role to play, both by defending the independence of the judiciary and by ensuring that the rule of law is respected within government. The Constitutional Reform Act of 2005 substantially changed the office of Lord Chancellor. He's no longer the head of the judiciary or Speaker of the House of Lords, and since 2007 the office has been combined with that of the Secretary of State for Justice. Yet the duty of the Lord Chancellor in relation to the rule of law remains unchanged. This duty extends beyond the work of the Ministry of Justice and requires the Lord Chancellor to ensure that the rule of law is upheld within the Cabinet and across government." End of quote. They also emphasised, Mr Chair, that the Lord Chancellor has traditionally performed an important oversight role in relation to the United Kingdom Constitution as a whole, and I would argue that this is highly relevant to the implications for Northern Ireland and for Scotland's place in the Union, which arise from the Internal Market Bill. And indeed, the House of Lords Committee heard evidence from Lord Faulkner, who of course was very much involved in some of these reforms which took place under the previous Labour government. The House of Lords Committee heard evidence from Lord Faulkner that the Lord Chancellor has a special role to protect the rule of law, and that to think otherwise was to undermine what the Constitutional Reform Act actually had sought to do. So, in summary, the Lord Chancellor's duty to respect the rule of law extends beyond the policy remit of his or her department, and it requires him or her to seek to ensure that the rule of law is upheld within the Cabinet and across the government. And my purpose in bringing this debate today is to draw attention to the very real threats to the rule of law currently posed by actions of this government, and to ask the Lord Chancellor, having regard to his oath, what he intends to do about them. Now, there have been trenchant criticisms from a number of quarters, very fully rehearsed in debates in this House, about the legal implications of Part 5 of the Internal Market Bill. For example, the Bar Council and the Law Society of England and Wales have said that the clauses contained in Part 5 of the bill, and I quote, "enable ministers to derogate from the obligations of the United Kingdom under international law in broad and comprehensive terms and prohibit public bodies from compliance with such obligations. They represent a direct challenge to the rule of law, which include the country's obligations under public international law." And as we have heard, that is why the Advocate General for Scotland tendered his resignation. Now, the Attorney-General for England and Wales has attempted to justify her support for the Internal Market Bill by reference to the legal doctrine of the supremacy of Parliament and the judgment of the UK Supreme Court in the first case taken by Gina Miller about the circumstances surrounding the triggering of Article 50. Now, in that case, the Supreme Court held that to be binding in domestic law, treaty obligations require to be enshrined in an Act of Parliament. But they also held that treaties between sovereign states, such as the Withdrawal Agreement, have effect in international law and are not governed by the domestic law of any state. And they were quite clear that such treaties are binding on the UK under international law. Now, I believe that the Attorney-General has selectively quoted this case in order to justify her view of the Internal Market Bill, and I want to know if the Lord Chancellor agrees with me that a proper reading of the case makes a very clear distinction between the domestic law and the doctrine of supremacy of Parliament and the United Kingdom's international legal obligations. And this was made very clear when Professor Catherine Barnard, Professor of European Law at the University of Cambridge, gave evidence recently to the Committee on the Future Relationship with the European Union. She was crystal clear that while the United Kingdom Parliament may be sovereign under domestic law, this does not impact on the rules of international law. And Articles 26 and 27 of the Vienna Convention mean that in international law, international legal obligations take precedence. Professor Barnard also explained that there is a strong argument that the very existence of the bill itself, it puts the United Kingdom in breach of its duty of good faith under Article 5 of the Withdrawal Agreement. Now, I emphasise this because I've no doubt it will be argued later today that the government amendments prompted by the action of the Honourable Member for Bromley and Chislehurst cure any problems that the Internal Market Bill Part 5 poses for our international legal obligations. I'm going to argue that's wrong for a number of reasons, and one of the reasons is the arguments outlined by Professor Barnard that the very existence of the bill, the existence of the evincing of an intention to unilaterally breach an agreement freely entered into less than a year ago, in itself is a breach of the withdrawal agreement and our duty of good faith under that withdrawal agreement. Now, I know that many cheerleaders for the bill in Parliament have been keen to emphasise Section 38 of the Withdrawal Act, which restated the principle of the sovereignty of the Westminster Parliament. Of course, Mr. Chair, that doctrine is a doctrine of the domestic law of England. It doesn't reflect the Scottish constitutional tradition, but that's perhaps an argument for another day, but worth mentioning because this Parliament here is a union parliament, a parliament that was created by a treaty between two sovereign nations, Scotland and England. The United Kingdom is not a unitary state. It's a state of two countries that came together to form a union. And this is a fact which is of relevance when we come to look at the impact of what is now Clause 47 of the Internal Market Bill on the supervisory jurisdiction of the Court of Session in Scotland. It's also a point which may be of some relevance should the Scottish Government carry out its threat to litigate over the terms of the Internal Market Bill. Now, the Honourable Member for Stone, who I have in common with him a great respect for Lord Bingham, but otherwise in relation to many matters of law we rather depart ways. But he has been peddling a line in Parliament that there's a history, albeit a limited one, of Acts of Parliament which have broken international law. But I was very pleased to hear Lord Sumption say very trenchantly recently in an interview on The World at One that this argument that the Honourable Member for Stone has been advancing is, and I quote, absurd. And Lord Sumption said it's absurd because it ignores the fact that sovereign states, such as the United Kingdom, can limit their freedom of action by treaty, and very frequently do, just as the Prime Minister did last year when he signed the withdrawal agreement. And Lord Sumption stressed that there's no right to pull out of a treaty unless the treaty itself enables a party so to do. And a party to a treaty cannot disregard parts of it at will. That is a matter of international law. There's also a potential problem and I'd like the Lord Chancellor and his representative here today to address the problem with the Ministerial Code. And again, I'm not going to say what I think about the Ministerial Code. I'm going to say what the former Deputy Prime Minister, Sir David Lidington, said in a letter to the Times last month, when he said, "Sir, my old friend Sir Bernard Jenkin is mistaken in believing that revisions to the Ministerial Code in 2015 removed the duty to comply with the UK's international legal obligations. My clear understanding, as a serving minister at that time, was that international law continued to be covered by the general duty placed on ministers to uphold the law. In 2018, a campaign group sued the May government, alleging that the 2015 change meant that we had abandoned our international legal responsibilities. The Court of Appeal found their case to be unsustainable and ruled that a minister's overarching duty to comply with the law included international law and treaty obligations, even though these were no longer explicitly stated in the Code." And that's the end of Sir David Lidington's letter. Now, the Lord Chancellor's minister will know that Sir David was referring to the Gulf case. What I want to know is, does the Lord Chancellor's department accept that Sir David Lidington was correctly stating the law? And if so, what does the Lord Chancellor make of his duties under the Ministerial Code in relation to a bill of this Parliament, which, according to Professor Catherine Barnard, the very existence of which is a breach of international law? The Lord Chancellor himself has endeavoured in the public domain to justify the fact that he hasn't, unlike the Advocate General for Scotland, resigned as a result of this bill. And he told Sky News last month that he would resign if the government broke international law in a way that cannot be fudged. I wonder whether we could have it explained to us today whether the Lord Chancellor's position is that the UK government is already breaking international law, but he's happy with that because they're doing it in a way that can be fudged. He also said that he will resign only if the government break the law in a way that is unacceptable. And I'd like to hear today, what is an acceptable way of breaking the law? I'm sure the thousands of ordinary members of the public who've been fined for breaking lockdown regulations, while Mr Cummings did so with impunity, would like to know from the Lord Chancellor's department how he distinguishes between acceptable and unacceptable breaches of the law. Now, the Lord Chancellor has also tried to argue that the amendments crafted by the government and prompted by the Honourable Member for Bromley and Chislehurst mean that the powers now contained in Part 5 of the bill will only be used if the European Union is in material breach of its obligations. And he's described it as a break glass in case of emergency provision. Now, there's a number of problems, I would argue, with this argument. First of all, there's the evidence of Professor Catherine Barnard, who told us that the future relationship with the EU committee, that the very existence of the bill itself, there's a strong argument that that is already a breaking of the obligation of good faith in the withdrawal agreement. Some of the other arguments have been very well made by a speech by our former Prime Minister, the Right Honourable Member for Maidenhead in the Commons just a few days ago. And she said, and I quote, "I recognise that my honourable friend, the member for Bromley and Chislehurst, has taken every effort to ameliorate the impact of these clauses." She was referring to Part 5. She went on to say, "and the government have accepted and put down their amendment. But frankly, my view is that to the outside world, it makes no difference whether a decision to break international law is taken by a minister or by this Parliament. It's still a decision to break international law." And that's the end of the quote from her speech. And I would point out that we have seen very much from comments not just of the Irish Foreign Minister, who described these amendments as smoke and mirrors, but also from comments from both senior Democrat and Republican politicians in the United States of America, that what really matters is the international perception of this bill. And I think what the former Prime Minister was trying to persuade her colleagues in government is that these amendments really don't make any difference to that international perception of what this bill is doing and seeks to do. Now, the former Prime Minister also reminded us that in the withdrawal agreement, there's an arbitration process set down. And she said, and I quote, "There is an arbitration process available. Under Article 175, the ruling of the arbitration panel should be binding on the UK and the EU. The government have acknowledged the existence of the arbitration procedure, but they're saying that they would enter into that in parallel with the operation of elements of this bill. The message, it seems to me, is very clear, which is, if we don't like the outcome of the arbitration panel, then we will break international law and we will not accept it." Yet again, that is breaking the international treaty, an agreement that the UK government signed, because it's breaking Article 175, which says that the view of the arbitration panel shall be binding on both parties. End of quote. Those are the words of the former Prime Minister of the United Kingdom, the Right Honourable Member for Maidenhead, not mine. And I wonder whether, in the light of this very distinguished criticism, if I may so, how the Lord Chancellor can reconcile his support for this bill with his oath of office. Now, finally, Mr Chair, I want to turn to look at the implications of the Internal Market Bill for the union between Scotland and England, and also for the position of Northern Ireland, which I'll address first. And in addressing the implications of this bill for Northern Ireland, I make no apologies again for quoting what the former Prime Minister said in her speech about this bill in the Chamber. She said, and I quote, "I believe that the government's willingness unilaterally to abandon an international agreement or parts of an international agreement they have signed, and their willingness to renege on an agreement they have signed, will lead, as has already been made clear in an intervention, to some questioning the willingness of the government to fully uphold the measures in the Belfast Good Friday Agreement. That, in turn, will lead to some communities having less willingness to trust the United Kingdom government, and that could have a consequence on the willingness of people in Northern Ireland to remain part of the United Kingdom. So far from acting to reinforce the integrity of the United Kingdom in pursuit of trying to appear to be tough to the European Union, I think the government are putting the integrity of the United Kingdom at risk." Close quotes. Again, the words of a former British Conservative and Unionist Prime Minister describing the implications of this bill for the Good Friday Agreement. Also, Mr Chair, it has very concerning implications for undertakings made in respect of human rights protections in the north of Ireland from the British government, both in the Good Friday Agreement and in the Withdrawal Agreement. Again, not my view, or not just my view, the view of the Northern Ireland Human Rights Commission and the Equality Commission for Northern Ireland, who have advised, and I quote, that the bill undermines the Belfast Good Friday Agreement to ensure incorporation of the ECHR, including access to the courts and remedies for the breach of ECHR rights. The Commissions are further concerned that the proposed amendments risk diminishing the commitment in Article 2.1 of the Northern Ireland Protocol to ensure there is no diminution of rights, safeguards or equality of opportunity as the United Kingdom leaves the EU. Close quotes. And I think it's been made very clear in the Chamber by honourable members who represent the Social Democratic and Labour Party and the Alliance Party in the north of Ireland that these concerns about human rights implications of the Internal Market Bill go right to the heart of the Good Friday Agreement. And indeed, litigation is already contemplated by a group of concerned Northern Ireland citizens who have instructed solicitors and counsel. Now, turning to the position of Scotland, which, of course, as the Member of Parliament for Edinburgh South West and the SNP's Justice and Home Affairs spokesperson are of particular concern to me. As well as breaking international law, the powers which the UK government seeks to give itself in the Internal Market Bill constitute an unprecedented threat to the powers of Scotland's Parliament and the devolution settlement. Now, why is this relevant to the Lord Chancellor's oath to uphold the rule of law? It's relevant because, as we saw from the House of Lords Constitution Committee report, the Lord Chancellor also has an important role in protecting the Constitution of the United Kingdom. And the Constitution of the United Kingdom includes the devolved settlement. Now, last weekend in Scotland, we marked the 20th anniversary of the late and very distinguished Labour Party politician, Donald Dewar, who was Scotland's first ever First Minister under devolution and the architect of the scheme of devolution set out in the Scotland Act of 1998, whereby every power not specifically reserved to this Parliament is devolved to the Scottish Parliament. But what this bill does, Mr. Chair, and this is not my analysis, I am reading now from the analysis of Professor Michael Keating of the Centre for Constitutional Change. What this bill does is, for the first time, to introduce a new principle into the devolution settlement by providing broad cross-cutting powers to allow ministers to enforce internal market provisions across devolved fields. And Clause 50 reserves state aid to Westminster after a dispute in which the Welsh and Scottish governments argued that it had been devolved. And Clause 48 gives UK ministers wide powers to spend in devolved fields, which changes the previous assumption that they would spend only in reserved fields and that, with a few exceptions, financial transfers to the devolved administrations would go through the block allocation governed by the Barnett formula. Now, that is why that succinct analysis by Professor Michael Keating is the explanation of why the bill undermines the devolved settlement. Holyrood is not getting any new powers that it didn't have already, but Westminster is getting sole control over state aid back, and in order to enforce the internal market, UK ministers are getting an explicit power to cut across decision-making by the Scottish Parliament in a whole range of devolved fields. And it seems to me that what we are seeing, Mr. Chair, by virtue of those provisions of the bill, is a rebalancing of the constitutional settlement insofar as devolution is concerned, and a tearing up of the very clear delineation between reserved powers and devolved powers that was devised by the late Donald Dewar and set out in the Scotland Act of 1998. Now, this is very important, not just because it undermines the devolved settlement, but it's important from a wider constitutional perspective. Because in 2014, when people living in Scotland were asked whether they wanted to remain part of the United Kingdom or to become or to return to our previous status as an independent sovereign nation, various promises were made by those urging us to remain part of the United Kingdom. In particular, that if we did so, our Parliament would get more powers, would be strengthened, and would become, to quote another Labour politician, the most powerful devolved Parliament in the world. But these weren't promises just made by Labour politicians. They were promises made by Conservative and Unionist politicians, who of course now are the party of government in the United Kingdom. And in 2016, a further Scotland Act was passed, which put the Sewell Convention on a statutory basis and entrenched the Scottish Parliament against abolition. In terms of Section 63A of the Scotland Act, it cannot be abolished without a referendum in Scotland. The Internal Market Bill circumvents these protections, not by abolishing the Scottish Parliament, but by removing the power it previously had to act unilaterally across a whole range of competences which impact on the day-to-day lives of people living in Scotland. It's a very significant change, and some would say a complete and absolute undermining of the devolved settlement, which 75% of people voted for in the 1997 referendum. And we now know, thanks to the decision in the United Kingdom Supreme Court in the first Miller case, that the Sewell Convention wasn't justiciable despite being put on a statutory footing. And we also know, because of subsequent actions of this government, that the Sewell Convention cannot protect the devolved settlement. The Sewell Convention, of course, says that Westminster will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. But recently, Mr. Chair, that has been honoured more in the breach than in the observance. Last week, the Scottish Parliament withheld legislative consent to the Internal Market Bill, but nobody seriously thinks that it won't proceed because of that. Indeed, the Institute for Government have recently said that the Sewell Convention has been broken by Brexit. I would argue that this bill, the Internal Market Bill, breaks the devolution settlement. And that's important because, as I've said, the constitutional relationship, the Constitution of the United Kingdom is the responsibility of the Lord Chancellor. And the constitutional relationship between Scotland and England is not just about devolution, it's also about the Act of Union. And that Act of Union continued because of promises made in 2014, which are broken by this bill. And I would suggest, Mr. Chair, it has been the suspicion of many people in Scotland for a long time that the British government's word is no longer its bond. That is a perception reinforced by this bill. But the problem for the Lord Chancellor is it's not reinforced just in Scotland. It's reinforced across the world. In Europe and as far as the United States of America, there are concerns about the implications of this bill for the rule of law. Just one final word on the Scottish aspects of this bill, because I've written to the Lord Chancellor about this and not as yet received a reply. I know he is a busy man, but I would be keen to know his position. Because I, like many lawyers in Scotland, not all of whom, like myself, want to see an independent Scotland, but all of whom care about the independence of the Scottish legal system, we're very concerned about the provisions in Part 5 of the bill and their implications for the supervisory jurisdiction of the Court of Session, the implications for judicial review. Because in Scotland, judicial review is part of our system of civil justice, which is a devolved matter under the Scotland Act and therefore the preserve of the Scottish Parliament. But more importantly, in the constitutional context, the pre-devolution context, the authority and privileges of the Court of Session, including its inherent supervisory jurisdiction, are protected by Article 19 of the Treaty of Union between Scotland and England. And it states, and I quote, that the Court of Session or College of Justice do after the Union and notwithstanding thereof remain in all time coming within Scotland, as it is now constituted by the laws of that kingdom, and with the same authority and privileges as before the Union, subject nevertheless to such regulations for the better administration of justice as shall be made by the Parliament of Great Britain. Now, Mr. Chair, it is a view widely held that legislation which sought to narrow the scope of the Scottish Court's powers of judicial review and to curtail the right of judicial review could scarcely be described as for the better administration of justice. Accordingly, should this United Kingdom government seek to circumscribe the supervisory jurisdiction of the Court of Session, then they would be interfering not only with the devolved powers of the Scottish Parliament, but also with the Treaty of Union. Now, I would respectfully remind the Lord Chancellor, as I did in my letter to him, that there is a large and respectable body of legal opinion to the effect that some parts of the Treaty of Union between Scotland and England, including Article 19, are so fundamental that the United Kingdom Parliament doesn't have the power to legislate in contravention of them. Now, this is an argument that has been discussed in a number of cases, but never definitively ruled upon. If it's intended to restrict the right to judicial review in Scotland, then I would venture to suggest that this might be the opportunity to get a court to definitively answer the question about the entrenchment of fundamental parts of the Treaty of Union. And of course, the outcome of such a litigation could have potential knock-on effects for the Union itself. So to summarise, really, my argument about the Internal Market Bill in relation to Scotland is we need to see it not only through just the prism of devolution, a modern development, but also through the prism of the Treaty of Union between Scotland and England. Without a Scottish law officer in place, this is an area in which the Lord Chancellor would be well advised I respectfully submit to take more of an interest. Now, I don't want to take up any more time because I know other honourable members want to speak. I just finish by saying that I've argued that there's a pattern here, and it's a pattern that the United Kingdom is finding ways to worm its way around laws and agreements freely entered into. And because of his oath to respect the rule of law, the Lord Chancellor is in a different class of minister. And the question is, what is he going to do about this pattern? What is he going to do to honour his oath? I note that in his speech on taking office, he spoke of his illustrious predecessors as Lord Chancellor of England and drew a comic veil over some of the less illustrious ones. And I guess, Mr. Chair, my question for the Lord Chancellor today is, does he want to be remembered as a Thomas More or a Richard Rich?
The question is that this House has considered the Lord Chancellor's oath and rule of law. Can I just say one thing first? The call list will be Sir Robert Neal, Rob Butler and Anthony Brown in that order. I would like to call the opposition spokesperson, the Minister, around 10:40 and give the member in charge, a Minister to respond at the end. So, Sir Robert Neal.
Thank you very much, Mr. Twigg. It's a pleasure to see you in the chair again. It's a pleasure to follow the honourable and learned lady, the member for Edinburgh South West. I have great respect for her as a lawyer, although we don't always agree on some of our political views. But I take on board what she says on legal matters very seriously. I ought also to mention my interests as a non-practising member of the English Bar, as a consultant to a law firm, and as a bencher of the Honourable Society of the Middle Temple. Can I perhaps start with the topic of the debate again, because the honourable and learned lady ranged widely in her speech, and I she'll forgive me if I don't follow some of the particular matters in relation to constitutional settlement and devolution that she understandably raised. But I want to concentrate upon the issue of the Lord Chancellor's oath. The irony of this debate is this, that the Constitutional Reform Act does indeed place the Lord Chancellor in a different position to that of other ministers, both because of the oath and because of their obligation under Section 17(1) of the 2005 Act to respect the rule of law and defend the independence of the judiciary. Ironically, the Blair government in 2005 never actually defined the rule of law in the Act, something which Lord Bingham, the late Lord Bingham, who's been much quoted already in this debate and probably will again, noted was interesting and rather unusual, that it placed great reliance upon a concept which is set out in statute but never defined. That, he concluded, clearly wasn't an accident. It was clearly because it was concluded that it was probably impossible, if not unhelpful, to find the sort of pithy statutory definition of something which has evolved over time. That could be put upon an Act of Parliament, and his conclusion in his admirable book, which I brought along this morning, is that it was desirable to leave the matter to be decided, as courts might need to from time to time, in the practical rather than purely in the abstract, as issues arose. I think that perhaps is wise. That means that it seems to me it is wrong, and some in recent weeks, since the arrival of the UK Internal Markets Bill, have sought to make rather ad hominem attacks upon the current Lord Chancellor, which I believe to be unjustified, firstly in terms of his own conduct throughout, and secondly in terms of making an assertion that the rule of law is potentially breached, but an assertion is of course no more than that, and a legal argument, however distinguished, be they by academic or legal commentators, is no more than that either. The reality, having known the Lord Chancellor for the whole of his professional career, is that he is absolutely rooted in his commitment to the rule of law, to the profession, and he made that clear when he took his oath, and he's made that clear repeatedly since. I will come to the Part 5 of the bill in a moment, about which my views themselves are well known. But I do believe, and I'm satisfied, that he has acted diligently throughout all of this to ensure that we deal with a potentially difficult situation in a way which is proportionate and consistent with our obligations. He's also been very clear since taking office in his support for the independence and integrity of the judiciary. I have to say, not all of his predecessors in recent years have been, and I say that frankly. There are people in all jurisdictions that we might wish to brush over, as the Honourable and Learned Lady put it. For every Lord Rich, there's a Lord Braxfield, perhaps, and others that we might wish not to dwell upon. But the reality is that the Right Honourable and Learned Gentleman, the member for Swindon South, has been meticulous in this. I note, too, his very clear statement in a letter, which I personally welcome, to the Right Honourable Lady, the Chair of the Human Rights Select Committee, his clear commitment of the government's continuing support for the provisions of the European Convention on Human Rights. So, again, he has been very willing to be outspoken around that. Reference was made to the risk of the rule of law being undermined by the government's proposals to examine the scope of judicial review. But when I started doing my law degree, I hate to say it, in the very early 70s at LSE, judicial review was a very new, in its modern concept, a very new and evolving legal concept. There was very little of it in those days. It grew, many of us will remember, through the Gourier judgment, the Grunwick case, and so on. And perhaps rightly so in many respects. But the truth is, there has never been a fixed corpus of law in the way which some issues, jury trial, for example, are. There's nothing wrong in that. That's the advantage of the common law system. It can evolve. But I don't think anyone would seriously say that prior to the development of the current system of judicial review in, let us say, the 70s through to the beginning of this century, I don't think anyone would seriously say that Britain was not a country that was subject to the rule of law prior to then. So a willingness to review the way in which judicial review as a concept operates and what are or not the proper limits can't of itself, I would submit, on any objective basis be regarded as an assault upon the rule of law per se. I will do just that.
I take that on board. But the difficulty is that the individual who's been put in charge of the review has evinced very strong criticisms of the Supreme Court's decision in the prorogation cases and has also evinced a hostility to the ECHR, notwithstanding what the Honourable Gentleman has already said. So I think there's a widespread perception in the legal profession that what is intended here is to circumscribe the rule of law, not just because of Lord Foulkes as the chair, but also because of the government's rhetoric. Surely he must see that.
Lord Foulkes is a fellow bencher of the Middle Temple, of course, and is, again, a very distinguished lawyer. It doesn't mean you always have to agree with everything that they say, and I don't think it will be fair or reasonable to judge somebody by past comments until you've seen, actually, the results of the panel as a whole. Lord Foulkes is the chair of that panel, but there are a group of other very distinguished people upon it as well. So I would respect, with every respect to the Honourable and Learned Lady, say this is a classic case of don't prejudge the issue until we've seen what actually the outcome of their deliberations are. I'm a great believer in judicial review in the appropriate cases. Has it sometimes been abused? I think many people would say that perhaps can be the case. I was very critical when I was the junior minister at the Department of Communities and Local Government of the attitude adopted to some decisions by the then Secretary of State, the Noble Lord Pickles, as he now is, and I, in relation to the removal of regional spatial strategies. We were judicially reviewed by very large commercial house builders, undoubtedly in pursuit of their own vested commercial interests, because they sought to prevent our removing the comparatively easy route for them to impose large housing developments on communities that didn't want them. Now, I was critical, frankly, of those house builders for doing that, for undermining what seemed to be the wishes of local residents. In law, the courts found that they were entitled to do it. But that doesn't mean that we were assaulting judicial review as a concept, simply by criticising the motives, perhaps, behind some of the people who bring it. There is an important distinction there, which I recognise, is that we criticised the clients, if you like, the people who have brought judicial review. I didn't criticise the lawyers who were instructed upon their behalf. And I wouldn't seek to do so. And I do think it's important to say that we should not, whatever our views in politics, use political arguments to attack lawyers generally or by broad brush approaches. The attacks upon the judges, which were not perhaps called out as much as they should have been at the time of the early Miller litigation, were wholly disgraceful and unacceptable. The current Lord Chancellor has made it absolutely clear that he would not countenance such attacks and such language without speaking out. That's very much to his credit and entirely consistent with his own personal integrity. I personally do not care for the use of language such as lefty lawyers or the broad brush approach of saying that systems are being hijacked. It's not language that I would use, but I'm a Member of Parliament, I'm not a speechwriter. And I just gently observe the Honourable and Learned Lady referred to the taxi rank principle at the bar. That's something that I've always worked under as well. To be fair, there have always been sets of chambers who wouldn't prosecute or who wouldn't act for landlords, for example. Now, some might say, is that, in theory, inconsistent with the taxi rank rule? Undoubtedly, it probably is. But I don't think it's something that it warrants a great degree of personal attack, but I just make that observation that these matters can't be seen in a purely calm and academic sense as far as that's concerned. So I wouldn't make too much of that, but I made clear where I stand as far as that is concerned. It's pretty clear where the Lord Chancellor stands, and I suspect where my honourable friend, the Minister, stands, as well as far as those matters are concerned. The other issue that is raised is Part 5 of the UK Internal Markets Bill, about which I have been not a little critical when it was first introduced. I do believe that we have sought to improve that bill. Is it perfect as yet? That I do not know. Would the use of the powers in Part 5 be wise politics? That I think is a very big question mark. But that's not the same as saying that it is per se constitutionally improper to put those clauses in the bill, provided there are appropriate safeguards. The Honourable Learned Lady and I might disagree upon that, but I think it's a legitimate area of legal dispute, and the Lord Chancellor is entitled to have a different view from her, and indeed perhaps from me, as far as that regard, without it being suggested that he has failed to uphold his oath of office or his constitutional obligations. I note that the views that have been referred to of Professor Catherine Barnard. She is a distinguished academic, and her views are worthy of being treated of respect. But by their nature, she not being a judge or a legislator, valuable though they are and worthy of respect though they cannot be determinative of the point. It's one side of an argument that can properly be put. And if on these matters there was no scope for a difference of opinion, no scope for difference of legal interpretation, no scope for legal argument, there would scarcely be any scope for litigation and scarcely any scope for lawyers at the end of the day. It's perfectly possible for respectable lawyers to hold different opinions around matters of this kind, particularly in emerging areas of law or new legislation as it comes forward, without it being appropriate for us to say that either side is seeking to undermine constitutional principles or their professional or governmental responsibilities. And I think that's the proper way to look at the position as far as that is concerned here. I'm glad to say, in response to some of the endeavours which I may have had a small hand in, the government has made it clear that effectively will be only using these powers should they ever be needed, and I hope to heavens that they are never needed, because we will get a deal, but should they ever be needed, there will be certain triggers that would have to be met, both in procedural terms, but also in terms of substance, and in particular, that we would only do so had the European Union themselves, in our judgment, demonstrated bad faith. Bad faith is recognised in international treaty law, in the Vienna Convention, as being a ground under which it is possible to derogate from an otherwise binding commitment. The fact that we will be using this as a shield rather than a sword is important. It's a sort of the doctrine of equitable estoppel in some respects. I think the Minister may well have more to say around this. But that's an important shift, and one which I welcome. And I think, therefore, the suggestion that the mere putting of those clauses on the face of the legislation is itself a breach of the law, isn't one that is universally accepted, and I don't think it's one that can be regarded, therefore, as an act of impropriety on the government or any minister's part. As I say, well, there's a proper political debate as to the wisdom of using them if we ever come to that, but that's not for today. Perhaps the final thing that I wanted to say in relation to this, Mr. Twigg, is this. Lord Bingham was very clear that the rule of law itself is something which can evolve, has to be flexible, but there are certain fundamentals. I don't think anyone would suggest that anything that we're doing here alters the basic fundamentals. I am conscious of his 8th principle, but as I say, I don't think we're at that stage, and I hope we won't be. But also parliamentary sovereignty, he accepted, was a fundamental part of the rule of law too. There is always a set of checks and balances in that regard. I have no problem with certain circumstances where the actions of ministers probably should be reviewed by the courts. Nobody's going, I think he's really going to change that. Lord Bingham made it quite clear, though, that he did not accept the view advanced by, for example, Lord Steyne or Baroness Hale of Richmond, that there are some concepts which are so fundamental that even Parliament cannot legislate to change them. He didn't take that view. Again, there's perfectly respectable dispute there, or disagreement, between highly distinguished former jurists. So again, it makes the point that none of the arguments powerfully advanced by the Honourable and Learned Lady are determinative of any failing by either the Lord Chancellor or any other minister in respect of their constitutional obligations. It's a worthwhile debate to have. In a sense, an hour and a half isn't enough to do it justice, because as we go forward, we are going to have to think about our constitutional and our legal settlements in a broader sense. How we will operate the separation of powers in a post-Brexit world. How, as I hope, with our continuing as a unified state with devolution within it, how we perhaps refine the arrangements that are required there to make that work in practice too. But all those are matters which are proper ones for further consideration, but don't, I think, impinge upon any proper allegation of any failure by the current Lord Chancellor or his ministers to act in accordance with their constitutional duties.
Before I call Rob Butler, can I just remind members that I intend to take the front bench around 22, so if you could keep your speech around 6 minutes so that the member for South Cambridgeshire can get in, then I'll be very grateful. Rob Butler.
Thank you, Mr. Chairman. It's a pleasure to serve under your chairmanship. I'm not a lawyer, let alone one with the esteemed reputations of other honourable or right honourable members, and nor am I an academic steeped in the study of centuries of history or intricate international treaties. But for 12 years before I was elected, I served as a magistrate, and for about 18 months was the magistrate member of the Sentencing Council, and consequently I do put very great store by the need to obey and respect the law, though I approach today's debate as a layman, albeit one with a firm idea of justice and a clear sense of right and wrong. And I also do so with great respect for the seriousness of the matters being considered. The rule of law is a central tenet of the UK's constitution. The office of the Lord Chancellor carries such prestige that it is higher than the Prime Minister as an officer of state in the order of precedence. Mr. Chairman, the twin subjects of today's debate are the oath of the Lord Chancellor and the rule of law, and I'd like to consider those in a fairly narrow sense, which perhaps reflects the naivety of a new Member of Parliament. The first element of the Lord Chancellor's oath is to respect the rule of law. And despite that being a term with which we're all familiar, its meaning is, as we've already heard, subject to considerable debate. A typical dictionary definition will elucidate straightforward principles, such as that all people and institutions are subject to and accountable to law that's fairly applied and enforced. Eminent jurists have emphasised the principles of accessibility, of power exercised in good faith, and of equality before the law, whether prince or pauper. And indeed, I well recall the emphasis on the last from taking my own oath as a magistrate, when I promised to do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. However, probing a little further reveals that the concept of the rule of law, and specifically in the context of the Lord Chancellor, is not as simple as it might at first appear. Indeed, as we've heard, the Constitutional Reform Act of 2005, which fundamentally changed the role of the Lord Chancellor, does not define the existing constitutional principle of the rule of law, nor the Lord Chancellor's existing constitutional role in relation to that principle. And like the Honourable Member for Edinburgh South West, I too have read the House of Lords Select Committee on the Constitution's 2014 report on the Office of the Lord Chancellor. And in addition to what she said, it also noted that the rule of law is not readily defined or readily understood, and went on to say, not all lawyers will agree on what the rule of law entails. Differences of opinion will undoubtedly also occur between different Lord Chancellors, and the rule of law remains a complex and, in some respects, uncertain concept. And those words are, I believe, significant in the context of the matters being debated today, indicating that we should not try to oversimplify and must surely accept that there is room for nuance of opinion. So let me move on to another aspect of the Lord Chancellor's oath, which is to defend the independence of the judiciary. Rare indeed is the suggestion that the British judiciary is anything but independent. Indeed, sometimes the press, the public, or even, dare I say it, politicians feel the judiciary is a little too independent. Many have been the tabloid headlines that criticise judges for imposing a supposedly light sentence on an offender whose crime has outraged public opinion. But that judge has invariably used their experience and knowledge to pass a sentence according to the law and to sentencing guidelines, and which can be appealed through higher courts, but not influenced by any political opinion. And even if there are protestations by honourable members at the level of a sentence, there is never seriously a proposal to have a form of political accountability for the judge or magistrate. And this remains the case even in judgments which go against the government, and we have seen more than a few of those in recent times. And I would submit that the independence of the judiciary is further reinforced by the role of the Judicial Appointments Commission, the independent body that selects candidates for judicial office in courts and tribunals in England and Wales on merit through fair and open competition. Mr. Chairman, the final element of the Lord Chancellor's oath is to discharge his duty to ensure the provision of resources for the efficient and effective support of the courts. Now, all of us who have served in the courts in recent years know they've experienced considerable reduction in resource as a result of necessary spending restraint by the government of the time. But there is now an ambitious programme of court reform which aims to bring new technology and modern ways of working to the way justice is administered that involves the investment of £1 billion in the courts and tribunal system. And I take this opportunity to highlight that during the current coronavirus pandemic, the courts have risen to the challenge from the Lord Chancellor to ensure that justice could continue to operate. In particular, magistrates' courts are responding magnificently, and consequently disposals have outstripped receipts since the end of July. And I also unashamedly highlight the initiative and imagination of staff at Aylesbury Crown Court in my own constituency, who've adapted their layout and ways of working so that they can be back working at 100%. Now, behind today's debate seems to be a question over whether the current Lord Chancellor is in compliance with his oath. Now, I have not, as I've said, been an MP for very long, but in my short time here, have met the Lord Chancellor on several occasions, have questioned him at the Justice Select Committee and on the floor of the House, have heard him speak from the dispatch box on all manner of topics. And, Mr. Chairman, one thing is abundantly clear to me. The Lord Chancellor is a man of the very highest integrity. He has spent his entire career in the law and respects the law to the core of his being. Indeed, at the ceremony to mark his swearing in, he said that he has sworn an oath to defend the independence and judiciary and respect for the law that has far more than formal relevance. And it's my firm conviction that he demonstrates his absolute and unwavering commitment to that oath day in, day out. Now, Mr. Chairman, I said a few moments ago I wanted to address the very specific nature of today's motion. In the few seconds that remain, I recognise it would seem odd were I not to say a few words about the Internal Markets Bill, which in many respects prompted the debate today. And I can say clearly it was a matter of profound importance to me, given the concerns that were raised about international law being broken. Now, probably the first thing I learned during my time on the bench was that it's important to listen to both sides of the argument before reaching a decision, not jump to a verdict immediately after the prosecution has presented its case without hearing from the defence. And I'm grateful for the time that the Attorney-General in particular spent talking to me about what was going on. But I have to say that the parliamentary lock that was achieved largely through the efforts of my honourable friend, the Chairman of the Justice Select Committee, combined with the knowledge that such a course of action would only ever be a last resort, provided me with necessary and sufficient resource. Mr. Chairman, the law is precious. It is both fragile and robust. Overseeing the rule of law is a profound responsibility marked by the weighty oath of the Office of Lord Chancellor, an oath that I submit is fulfilled with distinction by the current holder of that great office of state.
Thank you, Chair, and I'd like to congratulate the honourable member for Edinburgh South West for getting this important debate. I should say at the outset that, like my honourable friend from Aylesbury, I'm not a lawyer either, but I have, as a journalist, written a lot about international law, the making and breaking of international treaties, particularly EU law, as Europe correspondent for the Times. And I've also instructed a lot of lawyers. I've spent millions, probably tens of millions of pounds, instructing lawyers on international legal disputes, some with foreign governments, and I have to say I'm very proud to say that I've won every single case that I've been involved in. It is a painful experience, so I've got quite a lot of experience of dealing with the law. I just want to make 2 points. My comments obviously have to be brief, but really one about the Internal Market Bill, which prompted this debate to start with. I won't be addressing all the points that you raised, that my honourable friend did answer some of the points of. And secondly, about the impact that this has on the standing of the UK, which we haven't really talked about much today, but was very much part of the sort of political debate. On whether the Internal Market Bill Clause 5 breaks international law or not, I just want to draw people's attention to Article 6 of the Northern Ireland Protocol of the Withdrawal Agreement, which says, having regard to Northern Ireland's integral place in the United Kingdom's internal market, the Union and the United Kingdom shall use their best endeavours to facilitate trade between Northern Ireland and other parts of the United Kingdom. Now, the lawyers here will know that best endeavours is, in fact, a legal term, and it's a lot stronger requirement than just doing your best to agree. And the reason why the government passed this clause in the Internal Market Bill was in explicit response to the threat from the EU's negotiator, Michel Barnier, that actually the EU would not recognise the UK as a third country for agricultural produce, which would in fact have the effect of making it illegal for the UK to sell goods into the single market area, in particular Northern Ireland. That would ban trade for agricultural produce from England and Scotland to Northern Ireland. And that was unconscionable. Now, obviously, if the government had immediately used the powers granted in Clause 5, then that would have been a breach of international law. But that was not what it was doing. There's 3 triggers for using those powers. One is if there's no deal reached. We still don't know whether there'll be a deal or not. I certainly hope, like the whole House, I think that there will be a deal. Secondly, that there's no agreement of the Joint Committee on the border, the controls in Northern Ireland. And thirdly, after a vote in Parliament, if the EU breaches its best endeavours and actually does carry out its threat not to recognise the UK as a third country for agricultural produce, and if the EU did carry out that threat, then actually I think the EU would be in breach of its treaty obligations, and that would release the UK from its obligations, as my honourable friend mentioned before. And so in no way would this actually, if we ever got to use these powers, would it actually be a breach of international law in the circumstances that it is used. And I'm certainly very grateful for the fact that government recognised the importance of having a parliamentary vote just to make sure that doesn't happen. So I really do not think this is a breach of international law. Now, the second point I want to make is just about the impact of the standing of the UK, which has been a big, what a lot of the political debate and concern has been about. As I say, I've written a lot about international law, and the UK has been one of the sort of bastions of law-abiding in the international community for really for centuries and certainly for decades, and is very, very well regarded by other countries. One of the things I wrote about was the Maastricht Treaty in 1992, which Sweden signed and then held a referendum about joining the euro. And it was committed by international treaty to join the euro, but unfortunately the people of Sweden said no in the referendum, and then Sweden just said, no, we're not going to join the euro. And it is in permanent and a breach of its international treaty obligations. That does not make Sweden a pariah state, and I think one has to be slightly sort of grown up about these obligations. So just to summarise, as I noticed the motions from the Chair, this does not breach, I really do not think this breaches international law. I've taken advice from lots of legal friends about it, reaching the same conclusion, and even if it did, it wouldn't affect the international standing of the UK. Thank you.
Mr Lammy.
Well, can I begin, Mr Twigg, by congratulating the Right Honourable Member for Edinburgh South West for getting this very important debate this morning, and also declare an interest as an associate tenant at Doughty Street Chambers and a non-practising member of the Bar, and also a professor in practice at the Department of Law in the London School of Economics. The Magna Carta, the Charter of the Forest, habeas corpus, the Petition of Right, the Bill of Rights, the system of common law. For centuries, the United Kingdom has led not only in the creation of the rule of law, but in spreading it around the world. This simple but revolutionary idea was born out of two others. First, that there should be no power beyond or above the law, and second, the law applies equally to all people, women and men, rich and poor, black and white. Today, it is too easy to assume these principles always existed. They did not. And for many parts of the world, they still do not. Ask the people of the Congo, China, Russia, or Venezuela how life is without the rule of law. It was only won in this country as a result of human ingenuity, struggle, and tremendous sacrifice. I have to say I'm shocked to be standing here today debating the importance of the rule of law with a Conservative government. I've never been shy about my disagreements with Tories, but this is an issue on which I have previously respected the party now in government. The rule of law used to be fundamental to capital C Conservative thinking. It was the basis for all that Tories once valued: the ownership of property, security, the right to personal liberty, the freedom to live in a society without anarchy, fairness in business, law and order. From Edmund Burke to Margaret Thatcher, and even up to Theresa May, the rule of law has been just as valued on both sides of this House. So bipartisan was the British devotion to this idea that we became the global home of the law. The UK has the second largest legal sector in the world, second only to the United States of America. Its contribution of £60 billion to the UK economy, and it is one of our strongest global experts. Businesses and individuals from all parts of the globe flock to this country to write contracts in English law and settle disputes in our courts. They did this because they trusted us. Whichever party was in government, the rule of law would be respected. This is no longer the case today. There have been previous political decisions made by governments when the law was not entirely clear and when it was arguable either way whether an action was lawful. But this is not what we're talking about today. Last month, a cabinet minister stood up in the House of Commons and stated openly that the government will deliberately break the law. This did not force the Secretary of State for Northern Ireland to resign. It was a decision plotted in number 10 and supported by the whole cabinet. Most shamefully, it was backed by the so-called Attorney General and the so-called Lord Chancellor. Both ignored the special obligations of their offices in order to keep the keys to them. The Secretary of State for Northern Ireland's comments were not an aberration. They were a statement of intent for a government which appears to believe in lawlessness and disorder. The country will not forget the government closing down Parliament unlawfully. The public will always remember the arrogance with which Dominic Cummings broke the law after months of national sacrifice. We won't forget the shamelessness and the mendacity with which he explained away the breakings of the law that he helped to create. Under this government, the public is all thinking the same. One rule for us, another rule for them. One rule for us, another rule for them. One rule for us and another for them. The law must be the same for everyone. If it is not, respect for the rule of law ends. This should be self-evident. It's a great shame that a principle this fundamental now has to be fought for once again. And it is not only the law itself which is to be targeted by this government, but also the lawyers and the judges who spend their time dedicated to upholding it. When Hungary's Prime Minister Viktor Orbán rammed a law through Parliament undermining the independence of the country's judiciary, we all condemned the regime's shift towards authoritarianism. When the Polish government passed a law to make it possible for judges to face disciplinary measures when they make rulings that the government does not like, Labour and Conservative supporters were equally appalled. Brits from all political traditions should be just as outraged by the UK government's attack on the judicial review, because it is from the same authoritarian playbook. On the 3rd of September, the Home Secretary said that deportations were being frustrated by activist lawyers. In doing this, she was not attacking activists, but inciting anger against immigration lawyers for representing some of the most vulnerable people in our society. Words have consequences. On the 7th of September, a man with a large knife entered a London law firm and threatened to kill an immigration solicitor. Cause and effect. The Law Society was forced to write to the government and say, it must be ensured that no further lives are endangered as a result of the Home Secretary's untruthful and deliberately inflammatory rhetoric. Put simply, this must stop now before innocent lives are taken and other irreparable harm is done. Who will stand for the law, Mr. Twigg? Not the Prime Minister. A Conservative Party conference, he launched his own attack on lefty lawyers. This debate is not about partisan politics. It is about the future of our democracy. It is about the safety of our communities. It is about the freedom that order can bring. Respect for the rule of law is for the benefit of every person in this country, whatever their political views. Without it, we descend into barbarism. The rule of the jungle, anarchy, lawlessness, disorder, and mob rule. Attacks on the rule of law undermine the very basis of our civilization. Enough is enough. This Conservative government must remember its principles before they are lost forever. As Margaret Thatcher once said, being democratic is not enough. A majority cannot turn what is wrong into right. In order to be considered truly free, countries must also have a deep love of liberty and abiding respect for the rule of law.
Thank you very much, Mr. Twigg. It's a pleasure to serve under your chairmanship, and it's a pleasure also to be responding back here in Westminster Hall. And I congratulate the Honourable Lady for Edinburgh South West for securing this debate, and I thank her for her wide-ranging but tightly argued and important representations. May I say that I have, I think, 12 minutes to respond to her points, which were made quite properly at greater length, and I hope she'll forgive me if I'm not able to touch on every point that she raised. So this debate focuses, as its title indicates, on the Lord Chancellor's oath and the rule of law. It's important to note a point that won't be lost upon the people in this chamber, but does bear emphasis, that the role of the Lord Chancellor is different from that of the law officers who provide legal advice to the government and assist the government to find lawful and proper ways of achieving policy objectives. The Lord Chancellor does not provide legal advice to the government of the day, and his duties, whilst of course very important in their own right, are different. The Lord Chancellor's oath was, as we've heard, set out in the Constitutional Reform Act 2005, which preserved the principle of the, quotes, rule of law, and went on, as the Honourable and Learned Lady has already indicated, that I will, quotes, respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provision of resources for the efficient and effective support of the courts for which I am responsible, close quotes. So the Act, as it's immediately apparent, doesn't define specifically the constitutional duty in respect of the rule of law. And there are arguments, might be overstating it, but there are certainly difference of emphasis about the scope and content. The 2014 report of the House of Lords Constitution Committee, which we've heard reference to, did discuss this very issue of scope. And interestingly, as I went back to it, it was Dominic Grieve that said in his evidence that the duty was currently considered to relate to his department rather than the wider overarching guardianship role. But as the Honourable and Learned Lady said, Lord Faulkner took an entirely different view, and the committee overall thought that it was wider. The Cabinet Manual is silent on this particular topic. It refers to the law officer's role in, quotes, helping ministers to act lawfully and in accordance with the rule of law, close quotes, but it makes no mention of the Lord Chancellor's duty in that respect. One thing is tolerably plain, that the role has evolved since, of course, the judicial roles fell away. And as the report itself noted at paragraph 63, because of those changes, the roles of other individuals and institutions have taken on a greater importance in this respect. None of this is in any way to downplay the role of the Lord Chancellor, which remains very important, but it does have to be set in a wider context. So that's about the scope. What about the content? The Honourable and Learned Lady, and indeed others, the distinguished chairman of the Select Committee, the Justice Select Committee, has referred to Lord Tom Bingham's magisterial work, The Rule of Law. And he identified the core principle of the rule of law as being, quotes, that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered in the courts. He did, as she rightly indicated, respectfully, go on to outline 8 principles. We've heard reference to the 8th as well. It's also correct to say that other formulations exist. Professor Lon Fuller has written a distinguished treatise on the authority of law. But even if lawyers will debate its precise parameters, the expression the rule of law is generally accepted to include the principle that all people and institutions are subject to and accountable to law that is fairly applied and upheld. It's important we don't disappear down a rabbit hole on this. The expression is apt to include A, equality before the law, the point that the Right Honourable Gentleman powerfully made. 2, access to independent and impartial justice. And 3, a government subject to the law, a point that I will return to. These principles are indeed the bedrock of the freedoms and protections that we enjoy in a modern and mature democracy. The Right Honourable and Learned Lady is a lawyer, the Right Honourable Gentleman opposite is a lawyer, and indeed, as is the chairman of the Select Committee. And I recognise that lawyers play an important role in upholding those principles. As we know in this chamber, they have a primary and overarching duty to the court. Thereafter, they're obliged to fight their client's corner without fear or favour, and that means doing their best within the law to defend their client's interests, and doing so whether they agree with the substance of the claim or indeed the matter or not. And it was the Lord Chancellor itself, in comments that particularly resonated with me, who added in his Temple speech made at the opening of the legal year earlier this very month, he said this: "It is wholly wrong for any professional to be threatened, harassed or worse, attacked for simply doing their job. We must call it out and deal with it, and make the point that those who attack people providing a professional service will be subject to that very same rule of law." Well, I entirely agree with that. And it's not, of course, a purely British notion, although we might like to be proprietorial about it. Students of history will remember that future President of the United States, John Adams, who famously took on the role of defending British soldiers who were accused of the Boston Massacre at the end of the 18th century. That was a deeply unpopular thing for him to do personally, but he was absolutely right to take it on. So can I turn, please, to the principles that I've rehearsed. The first one, equality before the law. Let me take the opportunity to restate the Lord Chancellor's commitment to our long-standing tradition of ensuring rights and liberties are protected domestically and that our international human rights obligations are fulfilled. It was mentioned by the Honourable and Learned Lady regarding Northern Ireland. As he has set out in his letter to the chair of the Joint Committee on Human Rights, the UK remains committed to the Convention and we will continue to abide by our obligations under it. It was, after all, I'm sure we all know this, it was a Scots Conservative lawyer, Sir David Maxwell Fyfe, who played a central role in the formulation of its first draft after the horrors of the Second World War. The important point I want to make is that the Convention contains a number of rights, not all of which I'll restate here, but one of them, of course, is Article 14, which determines that the enjoyment of the rights and freedoms set out in the Convention and the Human Rights Act, quotes, shall be secured without discrimination on any ground such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth or other status. That matters because it's relevant to Article 6. For lawyers, perhaps the preeminent article, well, I suppose the right to life is quite important as well, but which Article 6 is the right to a fair trial. So our courts must do justice and uphold the fairness of the proceedings without discrimination. The Lord Chancellor himself is very conscious of that, and I pause to note that he has himself sat as a recorder of the Crown Court. Second point, and I will speed up, access to independent and impartial justice. An independent judiciary is the cornerstone of our constitution and democracy. Our judges are selected following a rigorous, independent, merits-based process, which is key to maintaining the quality, integrity and independence of the judiciary. Our Constitution recognises that. In a point that sometimes is lost, judges at the High Court and above cannot be removed from office without an address passed by both Houses of Parliament. Judges are also very largely immune from the risk of being sued or prosecuted for what they do in their capacity as a judge, and they also benefit from immunity from being sued for defamation for the things they say about parties or witnesses in the course of hearing cases. They can and must dispense justice fearlessly, without fear or favour, and may I take this opportunity to say they do that magnificently well, and we are extremely fortunate to have them. Those protections exist for good reason, and the Lord Chancellor jealously guards them. A government subject to the law. In his speech again earlier this month, the one that I referred to at Temple Church at the opening of the legal year, the Lord Chancellor said, quote, "Sometimes a lawyer will find the argument they advance to be at odds with the government of the day, but it frankly is a strength of our mature democracy underpinned by the rule of law that such debates can occur." Now, reform, which I accept from the right honourable gentleman he takes issue with, is not, we would submit, automatically to be rejected. There are many arrangements that can benefit from a considered examination. And if I may respectfully say, the Honourable Chair of the Select Committee made that point particularly powerfully. And so the independent, and I stress the word independent, review of administrative law endeavours to look at that. But let me say this, the baby will not be thrown out with the bathwater. Judicial review is at the heart of the rule of law in this country. It allows citizens to challenge the government and other public bodies. The Lord Chancellor himself is clear that the government needs to be challenged. And I simply make the point because I did listen to the points that the Honourable and Learned Lady said on that panel that she referred to with the former Supreme Court judge, and indeed Dominic Grieve and Lord Howard and others, Jessica Seymour, I think. There was a reference there made to ouster clauses, and I do want to make that point that there is nothing in those relevant sections which seeks to oust completely judicial review, and indeed if grounds were brought on, if a challenge was brought on the basis of procedural impropriety or all the other familiar grounds, that those are not themselves ousted. So it is important to keep those concerns in proper context. Provision of resources, I'm going to go a bit quicker now. The Lord Chancellor, I know, is personally committed to supporting the courts through this pandemic. I mention that because, of course, that's part of his oath, adequate resources. The Honourable Gentleman Member for Aylesbury was absolutely right. People seem not to have picked up on this point, but the Magistrates' Court are doing an incredible job. Since the end of July, disposals have exceeded receipts, and that is to their great credit. It is much more difficult in the Crown Court, we accept that, but the boost that has gone into to increase the amount of technology in the system, and indeed the maintenance budget, is very, very welcome, and it replicates a tripling of funding. So we're making progress across all jurisdictions. The scale of the challenge is unprecedented, even if the current volume of cases is not, and it could be necessary to look to further creative solutions in the future. Turning to UKIM in the minute that I have left available to me, the Honourable and Learned Lady is right. Catherine Barnard did say that the very existence of the bill is a breach of duty of good faith. She said that there is a strong argument to that effect, but respectfully, there are strong arguments in all sorts of directions. As the chairman of the Select Committee said, that is not of itself dispositive. Before turning to Part 5 in particular, let me state in general terms that the bill has been designed to offer business the certainty they need and to protect trade and jobs in every part of the UK. I don't accept for a moment that it undermines a devolved settlement, notwithstanding the powerful points that was made. When she mentioned Donald Dewar, I do pause to recall, yes, sometimes referred to as the father of the nation, but I remember his son saying in 2014, with great power in an article in the Daily Record, I think he said that his father, if he'd been alive with us today, would be an eloquent and passionate campaigner for Scotland to keep her place within the Union. I hope she'll forgive me making that point. Moving on. Part 5. Yes, look, the key point about Part 5 is, of course, I think, what was set out on the 17th of September by the government, a very important point. it would only be used, quote, in the case of, in our view, the EU being engaged in a material breach of its duties of good faith or other obligations and thereby undermining the fundamental purpose of the Northern Ireland Protocol. Let me close by saying I thank the Honourable Member for Edinburgh West for securing the important debate today, and let me make a couple of points or speak very quickly on a personal note. I am very pleased the Lord Chancellor is in post. He has practised as a lawyer, he has served as a recorder and well understands the law's central role in a fair, free, ordered society. The rule of law matters. The Lord Chancellor has an unshakable commitment to upholding it. I'm so sorry.
John Cherry. 9
Good
seconds.
debate, but I don't think there are any answers to the pointed questions I made. And what we need to remember is it's not a question of growing up, it's the question of the weight of legal opinion.
Order.
The weight of legal opinion on this bill is clear.
Order. We'll suspend the sitting for 2 minutes now, and could I remind members to leave via the entrance at the right-hand side. Virginia Crosby to move the motion.
Good morning. Mr Chairman, it's an honour and a privilege to serve under your chairmanship. I must declare an interest here in that I'm a member of the Armed Forces Parliamentary Scheme. And anyone who wants to spend time in my beautiful constituency of Anismore will know that there's an RAF base there. They may never have seen or even heard of it, but they know it the first time one of the Hawk jets goes overhead. This is also a great way to spot a local. Locals rarely look up when the planes fly over. They simply pause their chat for a few seconds and resume naturally when the noise has passed. Visitors, on the other hand, stand there with a shocked look that says, "What on earth was that?" My children hear the jets as they fly over our home near Valley, and I say to them, it's the sound of freedom. RAF Valley has long been a flying training station for the RAF and Royal Navy. It is the home of No. 4 Flying Training School, where No. 25 Squadron, under the command of Wing Commander Tim Simmons, and No. 4 Squadron, commanded by Wing Commander Jamie Buckle, provide advanced jet training for the next generation of RAF and Royal Navy fighter pilots. They train in the BAE Systems Hawk T2 jet, which has advanced avionics and which is the perfect lead-in trainer for pilots moving on to frontline aircraft, such as the Typhoon and the F-35 Lightning. No. 72 Squadron, led by Wing Commander Chris Ball, joined the base last year. They carry out basic flying training in the Texan T1 aircraft. RAF Valley provides 2/3 of the UK's fast jet training, delivering basic and advanced courses. The pilots trained at RAF Valley go on to secure the skies, protect the UK airspace at home and defend the UK interests overseas. The station is home to the UK military flying training system, one of NATO's most advanced fighter pilot training programmes, and RAF Valley is an acknowledged centre of excellence. Essentially, it's Britain's equivalent of Top Gun. RAF Valley is also the base for the RAF Mountain Rescue Service, which is expertly led by Squadron Leader Ed Slater. His team is on call 24 hours a day, 365 days a year to save lives and support the UK and local emergency services. Barely a day goes by in the summer without the Daily Post citing another daring rescue in Snowdonia. It's the kind of press coverage that my team can only dream of. 202 Squadron are also based at RAF Valley where, under the leadership of Squadron Leader Martin Jarvis, they teach UK military helicopter crews highly skilled maritime and mountain flying techniques. There has been a base at RAF base here since World War II, when it was established as a fighter station to defend Merseyside, the industrial north and the Irish Sea from enemy air and sea activity. From 1943, it became a major staging post for USAF aircraft arriving from the United States to help the war effort. It has long been established as an operational training base. Arnismorn is rightly proud of its RAF heritage, and RAF Valley is an integral part of the fabric of Arnismorn. And I must declare a further interest here. My grandparents were in the RAF during World War II. Indeed, it's where they met. So I have a real passion for the service, as I wouldn't be here without it. RAF Valley is more than just a military base. It is the second largest employer in Anglesey after the local authority. It has a whole force of around 1,500 personnel, made up of approximately 350 military and civil servants and 1,150 industry partners. My pleasure.
Congratulate the Honourable Lady in bringing this forward. In the short time that the Honourable Lady's been in this House, she has shown industrious efforts on behalf of her constituents. It's recognised by everyone, including myself. I just want to put that on record. Does the Honourable Lady not agree, as you just referred to, the numbers that the work already carried out in the past by the RAF, by the 1,500 service personnel, civil servants and contractors, has shown that it's essential for the area, not just for the RAF station, but also for the community. And the relationship between the RAF and the community is very important. Does she agree that the Minister should respond to help her? Thank you.
Thank the Honourable Member for his kind words. And it's my absolute privilege to support Arnismorn. And I agree with the Honourable Gentleman at the significance that the RAF plays to the island. Many other local people are reliant on work in its supply chain, and many large companies support the station's output. BAE Systems, Babcock, Ascent, Affinity, Airbus Helicopters and ESS. From highly skilled engineers to kitchen staff and cleaners, every single one of them plays a key role at RAF Valley. It is a critical part of the island's economy. Many children from the base go to local schools and learn Welsh. Staff and their families integrate within the community, and many return to live on the island when they leave the RAF. The base is an integral part. The whole force team, led by Group Captain Chris Moon, intentionally developed close formal and informal local connections. Engagement activities include community council briefing days, working with Bangor University on history research projects, and liaising with Wales Armed Forces Covenant stakeholders. They've actively supported the local Island Games team, which we've just learned it's just won its bid for the 2025 40th anniversary of the International Island Games, which will be held on Arnismorn. RAF Valley organises safety campaigns, works very closely with the local aviation society and provides personnel who support the local RNLI, mountain rescue and first responders groups. The rural outlying nature of Arnismorn means that activities for young people on the island can be sparse. There are high levels of youth unemployment and school attainment is generally below average, particularly for boys. Seeing that there was clearly a gap in the market here, RAF Valley operates extensive youth engagement programmes involving many local groups. Civilian and military personnel from the base in particular, June Stridehorse and Squadron Leader Graham Muscat, are proud to support the John Egging Trust with its inspirational and award-winning outreach programme for 14 to 16-year-olds. They've hosted the under-16 and under-18 Welsh Rugby Union training camp and offered junior football and tennis camps in association with the Isle of Anglesey County Council. With Bangor University, RAF Valley supports the Profi Project, an experimental learning and mentoring aimed at 18 to 24-year-olds, and STEM Cymru projects. They also work closely with Careers Wales to support youth projects across North Wales, helping young people establish transferable skills and find employment. For local school children, the station hosts on-site STEM activities and school days and also has active involvement in the Air Cadets, the Girl Guides and Scout movements. Many of the military personnel volunteer with local youth organisations whilst they're based at the camp. Indeed, RAF Valley has a very active Station Charities Committee, and many charities across North Wales have benefited from funds raised by the station. Charity Track Days, Aviation Society Spotters Days, and the Tour de Mont cycling event just give you a taste of what they do. And personally, I can't wait to stick on my white beard and face mask and join them on their Santa drop to Ysbyty Gwynedd Hospital this Christmas. From organising beach cleans, the thrift shop recycling project, to acting as custodians for a section of the famous Anglesey coastal path, RAF Valley is very definitely part of day-to-day life on Ynys Môn. And indeed, even the Padre, Mike Hall, who I met recently, told me that they're supporting entrepreneurs in their community centre. I'm fortunate the RAF community has embraced and welcomed me. I visited the station recently and was taken around by Group Captain Moon, who proudly showed off his station and in particular his dedicated and devoted staff. He told me, whilst the RAF might seem to be high-tech equipment focused from the outside, it is our people from across the whole force that really give us our edge. Some of our people have worked here for over 40 years, and if you cut them open, it would say RAF Valley on the inside. Whilst there, I saw and spoke to members of the whole force carrying out a range of duties, and from the minute I arrived on station, it was clear that there is a one-team approach on the site. Whilst visiting 72 Squadron, a squadron which played a key role in the Battle of Britain, I met many of the military and civilian personnel of Ascent and Affinity. They're rightly proud of the heritage of their squadron. There was a real team atmosphere, and it was great to meet the dedicated workers of Men-Eye Cleaning proudly wearing their 72 Squadron name badges. It was a privilege to have a go in one of their state-of-the-art flight simulators. Although my flying wasn't perfect, I was told it was similar to Gavin Williamson's. And I'm thinking of giving them a Top Gear-style leaderboard to track the parliamentarians that visit. Warrant Officer Nicky Jones showed me around the air traffic control tower where the professionalism and ability of the controllers was evident, as they safely and efficiently directed all of the Hawk, Texan and helicopter activities through the skies. I think Wing Commander Nikki Parr summed up the view of the team best when she said to me, "In a career of over 28 years within the Royal Navy and the RAF, Valley is the best place I've ever served, with absolutely everyone pulling together to achieve our aim of getting pilots to the front line safely." Skilled jobs are obviously critical to the operational effectiveness of the base. They are also critical to the economy of Ynys Môn. Our island is over-reliant on tourism, which, as we've seen only too clearly this year, is a fickle mistress. We need good quality, well-paid and reliable jobs for our young people to move into when they leave school. Too many are forced to leave the island to seek work elsewhere. RAF Valley, with its innovative technical partners, has provided a much-needed source of employment locally. The teams here provide excellent opportunities with high-quality training apprenticeships and long-term progression career possibilities. To give you a couple of examples, Lawrence Pears was raised in Holyhead and left school with no qualifications. He started working at RAF Valley in 2002, and today he's an experienced supervisor in the avionic and electrical trade. Indeed, it was Lawrence who got me in and out of the flight simulator when I visited the station. Lawrence said to me, "Please do all you can to keep giving the young people of this island the best chances in life if they wish to stay and live and make a reasonable living where they were brought up." John Pratchett, who was posted to Valley in March 1984, stressed that the Hawk T1 workforce has 40 years of experience and the force needs to retain and build on that collateral. He told me that he and his colleagues chose to remain at Valley because it's not only a workplace or a job to us, but a way of life. The island and nearby mainland are our home, and they've become our home. His team wants to stay on the island and pass their skills on to new generations of young people who desperately need the kind of training and support that RAF Valley can give them. Ian Blackie, who works on the T1 planes, told me that the RAF Valley team is absolutely critical to putting aircrew onto the RAF and Royal Navy front lines safely and on time. He said, "To maintain these 45-year-old fighter training jets requires knowledgeable, highly skilled and dedicated workforce. This knowledge and skill set are developed over many years and are unique to the RAF Valley workforce, both hands-on maintenance and technical support cells. I recognise and appreciate that BAE Systems' contract is currently under negotiation, and I in no way wish to interrupt those discussions. However, I do wish to impress on the Minister and the importance of RAF Valley to Ynys Môn. RAF Valley is not just an employer, it is a team, a family, and like all great teams, it operates efficiently because every part of it performs its own role and does it brilliantly. The people of Ynys Môn want to see RAF Valley grow and flourish. We are the energy island, an incubation of innovation, a place for technological creativity. RAF Valley is part of our DNA. This debate is not about current jobs. It's about ensuring the long-term future of RAF Valley. It's about keeping RAF Valley as a centre of excellence for training pilots in both the RAF and Royal Navy. It's about retaining and encouraging investment both in the base and its workforce. It's about ensuring that RAF Valley has the most up-to-date equipment, the best planes, and of course, the exceptionally high calibre of technical staff that it has spent years developing. I would ask the Minister to tell me not only how jobs will be maintained at RAF Valley, but more importantly, what jobs, apprenticeships and other opportunities he expects to be created for the next 20 years. I would ask the Minister to acknowledge the importance of RAF Valley and give his absolute assurance of the recognition and appreciation of the station by the MOD to Anglesey. Whilst I appreciate the negotiations are underway at this time, I want the Minister to acknowledge the significance of the RAF to Ynysmore. The people in my constituency are rightly concerned about the implications of the negotiations and the timescales to which they're being conducted. And so I would ask the Minister to set out exactly where negotiations stand at this time and when those impacted will know what is being decided. And finally, Minister, I want to look beyond 2025 and ask the Minister if he will work with me and other ministerial colleagues to get further operations to RAF Valley.
The question is that this House has considered the future of funding and employment at RAF Valley. Minister. Sorry, we haven't been noticed, have we?
Mr. Chairman, I don't know if I'm aware that the Honourable Lady had communication from the Honourable Gentleman, and it's also clear by my office, but I don't know whether the Honourable Gentleman has made it clear. But he can speak for himself.
Yes, I had submitted to speak, in fact.
Right.
And he...
Yeah, I haven't. Okay, sorry.
Thank you, Mr. Twigg, for your forbearance. Thank you. And could I just begin my short contribution by congratulating the member for Ynysmore for so accurately and passionately presenting the case for RAF Valley. Could I say that my particular interest and concern in RAF Valley stems from the fact that last year I completed the parliamentary scheme for the armed forces, and I was seconded to the RAF. And having completed the scheme and having graduated, I'm left with a huge admiration for the RAF and for the tremendous service they provide to this country. And as part of the scheme, I also visited RAF Valley. And as the Honourable Member has suggested, I was struck by the fact of the tremendous commitment of the entire workforce there, but also the huge contribution that RAF Valley makes to the well-being of the local economy. It is absolutely central to the future of Anglesey as a community. And I was enormously impressed by the fact that there's a special focus, as we've heard, on pilot training. It is the centre for pilot training for the RAF and to some extent the Navy in the United Kingdom. But I've got concerns as well too. And the concern is that 180 jobs could be kept from the essential Hawk contract at RAF Valley by 2033. And the fears of the workforce stems from the contract negotiations which are taking place, I understand, between BAE Systems and the Ministry of Defence for the T1 and T2 Hawk aircraft. For the T1 Hawk, there is an active proposal, so I understand, to move all the T1 depth maintenance to RAF Leeming by 2023. Now, this move alone could accelerate the loss of between 50 and 70 jobs at Valley. Now, it's been suggested by people who work there that this proposal makes no sense, either in a financial sense or in an operational perspective. And I'd like the Minister to specifically comment on that. Unite, the trade union, suggests that the move is not only ill thought out, but there's been a suggestion, no more than a suggestion, that perhaps the Chancellor has had some influence on the decision-making which is taking place, because Leeming is part of his constituency, of course. There's also concern that a further 100 jobs could be lost by 2033, and this is related to the T2 Hawk. And this could, in total, therefore, mean the loss of 180 jobs. And, of course, because The base is so central to the well-being of the island and the local economy. This would be a huge bloody blow to Anglesey. We know full well that the island has suffered a number of very difficult economic job losses over the last few years, and this would be a further and significant body blow to the island. So, like the Honourable Member for Annismore, I'm looking for reassurances and clarification from the Minister on the points I've mentioned and which she has mentioned as well. Thank you.
Thank you, Mr. Chairman. It's a pleasure to serve under your chairmanship. And if I may start by congratulating the Honourable Lady. I knew her before she arrived in this place. I thought that she would be a brilliant advocate for her constituents, and in the way she's been tackling me direct on this vital base and vital employer in her constituency, and in securing this debate, she's proved that absolutely the case. She is going to be a redoubtable representative for Annismore. I'm also delighted to hear that she is a member of the Armed Forces Parliamentary Scheme, serving with the RAF. I'm sure she'll learn more from them, and I'm sure that will be mutual. And I wish her well with the course. It's also a pleasure, and I'm grateful, Mr. Chairman, you allowed the Honourable Gentleman to make his contribution. It's good to see the Honourable Gentleman here, another alumnus of that scheme, and there is I know there's great cross-party support in support of our defence and in support of what defence means to Wales, which is incredibly important, as the Honourable Gentleman I know will accept. I'll come on to points he's made in my remarks. There are a few better examples of the value of defence to a local community than the situation in RAF Valley. My honourable friend raised some of the points of the history of the station, which is important, but I'm not going to dwell on that. I'm going to dwell on the present and the future, as she would wish me to do. British pilots and jets are occupied day in, day out in the defence of our country, our interests, and the free world. In the future, wherever those planes are taking off, to protect our airspace, to protect the airspace of our NATO allies, taking part in critical combat missions or flying off the decks of our deeply impressive 2 new aircraft carriers, the people of Annismore will know that those pilots have been trained and won their wings amongst them on the island. RAF Valley, as the Honourable Lady mentioned, works as a team, harnessing the talents of its cadre of service personnel, civil servants and contractors to train the pilots of the future, both for the Royal Navy and for the RAF. A crucial aspect of generating that team is the strong working bonds with the local communities, the local employees, and indeed, critically, as the Honourable Lady referred to, employees of the future. I know that what my honourable friend wants to see, and all who wish RAF Valley well, also wish to see, is ongoing investment and the provision of state-of-the-art aircraft, making manifest our commitment to that base's future. As the threat evolves, the training to meet that threat evolves, and the planes required for training evolve. We are committed to ensuring that RAF Valley is at the core of that evolution, and the evidence already at the base is very apparent. As a result of the decision to concentrate basic flying training at RAF Valley, moving, incidentally, assets from RAF Linton-on-Ouse in North Yorkshire to the island, more focus and investment has been delivered into the base. The station has not only benefited from the sizable part of the £3.5 billion set aside to deliver military flying training, but we have also recently specifically spent £20 million on refurbishing the runway. RAF Valley pilots are trained on the modern and sophisticated Texan and updated Hawk T2 aircraft. These are a great leap forward from the platforms that they replaced, with heads-up display that can accurately simulate weapon attacks and other threats, and which ensure the maximum training benefit from every sortie. The Government committed in SDSR 2015 to increase the number of fast jet squadrons and thereby the pilots to fly them, all of whom will be trained at the expanded training system at RAF Valley, with more Texan aircraft coming on stream to deliver that training. All levels of fast jet training at RAF Valley are being complemented by advanced synthetic training that can accurately replicate the complex and detailed realistic scenarios that they need to train for. And it's not only fast jet training that has had this treatment. The life-saving search and rescue training that also takes place at RAF Valley has also had the valuable boost in the form of the new Jupiter helicopter. The overall result has been aircraft and facilities that are amongst the most advanced in the world. Through the hard work of RAF Valley staff and the students themselves, RAF Valley is preparing to award Royal Navy and RAF wings to the first 6 pilots to have graduated on the Texan next month. A fantastic achievement and a huge moment in a young pilot's career. This is the culmination of years of effort and preparation. The impact on the ground in RAF Valley of our investment has been very clear. Between 2017-18 and 2019-20, our industrial partners who undertake the critical roles of servicing the aircraft and running the training systems grew their number of employees at the base from around 450 to just over 600. So there's nearly 150 additional personnel are being employed at RAF Valley to support the Texan and Jupiter aircraft. As the Honourable Member from Strangford pointed out, these new colleagues at the base that we welcome are part of a total team of some 1,500 delivering for defence. And we recognise the importance not only of investing in infrastructure and the jobs of today, but investing in the skills of tomorrow. The Honourable Lady made this point very powerfully, and she's absolutely right. At RAF Valley, we are very proud of the work done on STEM training. Across Wales, some 90,000 students had access to the RAF's first-rate STEM training programme last year. And I know the value of investing in people in North Wales, how it can generate lasting loyalty and an inspiring workforce. Babcock's sponsored 2-year apprentice programme in partnership with Coleg Menai in Bangor has run for 4 years, generating to date 29 apprentices qualifying in aeronautical engineering, and I'm proud to say that 28 of those still remain working at RAF Valley. A further 19 apprentices will graduate in the next 2 years and are currently in training. Babcock is constantly alive to the need to recruit and retain talent at the base. 7 employees remain who were redeployed from RAF Linton on Ouse, and cash awards, I know, are paid to employees who successfully refer new colleagues. And it's given that positive background on new assets that have moved to RAF Valley, of new roles created and skills training being delivered, that it is perhaps at that point that I should, and set against that context, that I should come on to the understandable concerns which brought the Honourable Lady here to this debate regarding the future and the recent speculation around the future of Hawk T1 maintenance and what that might mean for those currently employed by one of our commercial partners, BAE Systems. As my honourable friend will be aware, Hawk T1s are no longer used operationally from RAF Valley. The remaining Hawk T1s used operationally are based at RAF Leaming, Royal Naval Air Squadron at Culdrose, and in Lincolnshire with the Red Arrows. Whilst every capability is subject to the current integrated review, the Red Arrows T1s are expected to reach their out-of-service date in 2030, and the rest of the fleet reaching an earlier OSD in 2027. That was as set out in SDSR 2015. The RAF is currently undergoing a review of how best to deliver all aspects of servicing and maintenance for the Hawk T1s through to their OSDs. So my officials are in discussions with BAE Systems, and we are currently determining potential options for Hawk 2020 support contract. And I would like to emphasise, Mr. Chairman, that at this stage, no decisions have been taken. Any future decision will be based on a range of factors. Making the right operational decision is critical. So the RAF needs to ensure that its planes can be reliably serviced and constantly available. This emphasises the vital importance of continuing to grow the skills base to provide the engineers we need at RAF Valley and more widely. Naturally, we also need to consider value for money arguments. And we are also very keenly focused on the UK government's commitment to levelling up the whole UK and supporting the Union. Discussions are ongoing, and we will update the community as soon as any decisions are made. I re-emphasise that no decisions have as yet been made. The personnel of RAF Valley have a deep commitment to working with and supporting the local community. My honourable friend touched on this. There are many, many examples of that close working relationship. I know that there is indeed a strong team at RAF Valley delivering for defence and also delivering many benefits to the local community. The bonds are very, very strong. I would like to thank the Honourable Lady for giving me the opportunity to set out the current situation, and I'd like to thank all members for the interest they've shown and the recognition of the vital need to continue to train to the highest level of expertise our military jet pilots and the vital role played by RF Valley. I had hoped to be able to give the Honourable Lady a couple of minutes to reply. I don't believe I'm allowed to under the rules of the House, so I apologise to the Honourable Lady. That is an opportunity I hoped I'd be able to give her. I've not been able to, but I'd like to thank her again for bringing us to this chamber. The bonds, as I say, around RF Valley are very strong, as is our commitment to this vital and internationally highly regarded base. Thank you, Mr. Chairman.
The question is that this House has considered the future of funding and employment in RAF Valley. As many are of that opinion, say aye. Noes. The ayes have it. Order, order. The sitting is now suspended until 2:30. Can I just remind you that as you're leaving, can you go out on my right-hand side, please? I'd appreciate that. Thank you very much.